Welcome to my YouTube channel, VaJee Centre for Legal Excellence. Okay, here IBC Amendment series. Next, we are back with again what are the amendment done in Section 18. Okay, Section 18 Amendment clarifies the role of IRP. And now its role from collating to verifying and evaluating claims. Earlier, what is the position that uh, mm, what is position? Claim was submitted based on the journal rules, no uniform prescribed manner across the cases. Now, after the 2026 Amendment Act, in Section 18, subclause B, the phrase "in such a manner as may be specified" is inserted. It empowers the IBPI to prescribe how the claim must be submitted. This now IBPI have more control, more power to define. Now everything is now streamlined. IBPI may specify the standard formats and checklists, determine the timelines for the submission of claim, and they can also give digital filing and evidencing norm. They may specify and integrate it with the information utilities. Okay, this is in alignment in parallel with section 215 subsection 3, which mandates that the operational creditor must authenticate financial information with information utility before filing leads to pre-verified and reliable claims. Now what they say, that you have to report your debts. You have to create an evidence before the information utility. They give you a NESN report. That leads to that 14-day time limits are now achievable tax, because there is a lot debate on what is amount of default and what is the date of default that produces, because we have pre-verified evidence with us. Okay, then now second is that from collating to verification and valuation. New explanation is added in section 18, which removes any doubt about the active role of IRP in claim process. What happens when petition get admitted? IRP appointed, and his first job is to to constitute a first COC meeting. In first COC meeting, IRP status is confirmed. Sometimes IRP retain as RP in the CIRP process, or sometimes COC may change IRP. But whatever the case may be, next important step is collating the claim. Earlier, before 2026 amendment, IRP had to collate the claims, often seen as a clerical work, clerical task. Just he has to gather the documents. Now, this his role from passive changed to very active, proactive role. What he does now, IRP shall verify the claim and, if required, determine the value of such claim. Okay, check the what IRP must do now. Check the legal validity of the claim, existence of debt and supporting document, contractual terms, etc. Calculating the exact monetary value of the verified claim, including principal, interest, penalty if allowed. Why it matters now? Because accurate verification and valuation ensure that correct voting share in the committee of creditors. Okay, you know that every decision is how CIRP proceed. It's according to the commercial wisdom of COC, and COC exercise their commercial wisdom. Their vote matters according to the percentage of their debt own and what percentage of voting share they have. Okay, so that is very crucial point that that need to be in black and white. There cannot be any gray area. So by this amendment, that is now crystal clear. We have no doubts in consonance with what we having impact on liquidation. A slight change is also done. the amendment creates a continuity of data between the resolution and liquidation stage. Before amendment, what we have, section 38 to 42, which governs the detailed claim process and liquidation. If CIRP fails and adjudicating authority ordered a liquidation, then liquidator is appointed and liquidator had to invite a fresh claim, verify and adjudicate again, and maintain a new list. This resulted redundancy, delays, and higher costs because you have to restart a process again. Now, after 2026 amendment, what happened? Section 38 to 42 are omitted. Liquidator now maintain an updated list of claims based on the IRP verified and valued data. Updated the list as per the post-commencement events. Okay, there can be an update once the meeting finalized, COC confirmed, but if they're at a later stage within a timeline, if something added or subtracted, so they can change accordingly. Okay, but they need not to start from a zero. They need not to invite again a fresh claim and verify and adjudicate them again. Okay, and what are the particular outcome of this? That reduce duplication, faster decision, and better value realization for all stakeholder. Okay, that I give a short summary at a glance. Ki what is the situation earlier and what is now. Earlier, claim submission handled on a general rule basis. There is no specific guideline. Now the responsibility is with IBBI. That IBBI has to specify regarding the how the claims are submitted. If there is any particular checklist, digital evidencing, IU alignment, uh, these things are now specified by IBBI. Impact, what are the practical implications of this? That it creates a uniformity, reliability, and faster processing. Now, IRP duty, earlier he has to collate claim. Scope was ambiguous and more likely we can say that it's a passive role. But now he is given the adjudicating power. Slightly adjudicating power, he has to verify the claim and determine the value of such verified claim. Okay, active verification ensure accurate COC voting and reduce disputed. This leads to this. Okay, and now liquidation, transition to liquidation. Liquidator perform a fresh verification of claims. Earlier, before 2026 amendment, and there are provision of 38 to 42. Now they are completely removed from the IBC. Now the liquidator maintain an updated list based on the IRP verified data. Okay, and this ensure, what is the practical implication of this? This ensure the continuity of data, lower cost and quicker liquidation, because sometimes CD asset are not that much that they can even bear a liquidation cost. So that result somehow can all stakeholders are benefited by this particular amendment. Okay, and what are the systematic benefit? Earlier, what was the position? More dispute because no delays and administrative burden. Because what is the delay? What is the root cause of delay? Because it's in case of real estate cases, particularly when lots of home buyer are involved, and CD, if CD is not cooperating with IRP, there is no books of account and they are not providing any data to pull it, then it's very difficult for them. Now we have a pre-verified claim, and there is a systematic change. Everything is streamlined and everything is specified by IBBI. So the transition to CIRP to liquidation is also smoothed, and the whole CIRP process is also smoothed, because now the everything is have a SOP. We can say that. Okay, pre-verified claim, smoother resolution and liquidation, higher value for the stakeholder. What are practical implication of this? That stronger insolvency ecosystem, greater creditor confidence. Now this whole thing, whole thing leads to a clear start. we have determined COC, clear cut voting right, with clear cut voting rights. There is no dispute about it, and that leads to a fairer process and a stronger outcome. By making and verification and valuation of claims a core duty of IRP, the 2026 amendment ensured that the financial map of a debtor is accurate, trusted, and ready for every stage ahead. Okay, better data, better decision, better outcome for all. Because COC has to exercise a commercial wisdom, where he has to exercise and how it has to be exercised. Now it's on a clear cut roadmap. Because voting share, say suppose if someone has a 1300 CR claim, and according to his voting share is going to be decided, but say IRP only has a duty to collate, he didn't have a duty to adjudicate. They are producing evidence, but data books not maintained properly, or he didn't have particular information, though he cannot adjudicate. And they again have to come to adjudicating authority. Adjudicating authority already burdened with n number of things. So this reduces the whole litigation Pandora box, I guess so. Let's see when it's implemented how it works. Okay, hope this video helpful for you. Thank you.